Are you trying to choose between a will and a living trust? This decision can greatly impact your family's future, so stay tuned to find out which option might be best for you. In this video, I'm going to break down the key differences between a will and a living trust and help you understand which might be the best choice for your estate planning needs. As estate planning attorneys at Barid, we've helped thousands of families navigate these choices, ensuring their assets are protected and their wishes are honored. Our expertise and years of experience, we have over 50 years combined experience, give us a deep understanding of the advantages and disadvantages of both options. Hi, I'm estate planning attorney Mike Smith with Barid LLC, and I'm one half of the Estate Planning Guys. So let's start with a will. A will is just a legal document that outlines how your assets will be distributed after your death. So here are the main components and considerations of a will. First is the distribution of assets. You can specify exactly who will receive your assets and in what proportions. This can include family members, friends, and charitable organizations. Heck, you can even throw a stranger in there if you want to. Second, the executor. You can name an executor in your will, and this is the person who's responsible for managing your estate, ensuring that your wishes are carried out, and handling any debts or taxes owed by the estate. Number 3, guardianship. If you have minor children, a will allows you to appoint a guardian to take care of them in the event of your death. This is a critical function of a will for parents. Number 4, the probate process. A will must go through probate, which is the legal process of validating the will and overseeing the distribution of assets. Now, this process can take several months to years, depending on the complexity of the estate and whether there are any disputes. And the probate process makes the contents of your will a matter of public record, which means that anyone can see the details of your estate and who's going to inherit what. Number 5 is cost. And generally, creating a will is less expensive and less complicated than setting up a living trust. However, the costs associated with probating your estate can add up quickly, and it can end up costing a lot more than a living trust, which is what we'll talk about more in just a second. If you're finding this information helpful, please like this video and subscribe to our channel for more estate planning tips. Now, let's talk about a living trust. A living trust is a legal arrangement where you transfer ownership of your assets into a trust during your lifetime. Here's a closer look. The first thing is asset management. So you transfer your assets into the trust, but you are the trustee during your lifetime and you still manage the assets. So this includes things like buying, selling, and managing the assets in general, just as you did before. Number 2, successor trustee. You name a successor trustee who will manage the trust and distribute the assets according to your wishes after your death, or if you become incapacitated. So like if you developed Alzheimer's or you had a stroke. Number 3, avoiding probate. One of the biggest advantages of a living trust is that it allows your estate to avoid probate. This can save you time, reduce costs for your family, and it keeps your financial affairs private, unlike with a will where we have to file a probate. Number 4, incapacity planning. If you become incapacitated, your successor trustee can step in and manage your affairs without needing any court approval, and that can be crucial in maintaining your financial stability. Without that, your family could face having to file a conservatorship proceeding in probate court, and that can take a lot of time and cost a lot of money to conclude. Number 5, flexibility and control. A living trust can be revocable or irrevocable. A revocable trust can be changed or dissolved at any time during your lifetime, and that gives you a lot of flexibility. An irrevocable trust, once established, cannot be easily altered, so it's kind of set in stone, but it offers certain tax benefits and creditor protection, so it can be a good choice in the right circumstances. Number 6, initial setup costs. Setting up a living trust can be more complex and expensive than creating a will. It requires transferring ownership of your assets into the trust and can involve additional paperwork and legal assistance. To help you decide which option is right for you, we have some free resources, an estate planning guide, and some other resources that are linked in the description below. Now, let's compare the two, will and living trust, in a little more detail. First, simplicity versus complexity. And what I'll do is for each of these things, we'll talk about a will and then we'll talk about a living trust. So a will is generally simpler and less expensive to create. It's a straightforward document that outlines your wishes. But on the complexity front, it requires a probate, a legal proceeding when you pass away that's public. It can be time-consuming and costly. A living trust, it's more complex and costly to set up, and it requires transferring your assets into the trust. And then you have to maintain the trust during your lifetime. I think of it kind of like an automobile. You don't have to maintain your car every day, but you do need to get oil changes, and a trust is sort of the same way. The second thing is the probate process. A will must go through probate. That can be time-consuming, costly, and it's a public proceeding. A living trust avoids probate altogether, so that it allows for a quicker and private distribution of assets. Number 3, incapacity planning. Now, a will does not provide any benefits if you become incapacitated, so you would need a separate power of attorney to cover circumstances like that, as well as an advance directive for health care to take care of your health care if you become incapacitated. A living trust provides seamless management of your assets if you become incapacitated. No need to go to court. The successor trustee can take over management of the trust without needing any court intervention at all. Number 4, privacy. A will becomes a public record during the probate process, and that means that anybody can see the details. Back in the old days, they used to go down to the courthouse to pull a file. Now a lot of that information is available online, and so all kinds of people that you might not want to know the details of your estate and your family will be able to get at those details. With a living trust, everything remains private because it doesn't go through probate, so there's no need to file anything with the court. Number 5 is cost. A will is obviously less expensive to create, it's a bit simpler, but probate costs can be really significant. And so the overall cost with a will is either very similar to what it would cost to set up a living trust, or in some cases it costs a whole lot more to deal with a will through the probate process. So a living trust is more expensive and complex to create, but it can save a lot of money by avoiding probate on the back end. Number 6, ongoing management. With a will, there's no ongoing management during your lifetime, other than the fact that you need to update your will periodically because the law changes and your situation, both personal and family, changes over time. With a living trust, it does require ongoing management and updating of the trust as your assets and circumstances change. But I don't think it's a very onerous burden. It's not like you have to look at it every day. Once a year when you're doing your taxes or some other annual event like your birthday maybe, you sit down and you take a look at things. You might need to set up an appointment with your attorney to make sure that there have been no changes in the law, that sort of thing. But it's not a terribly onerous ongoing burden to keep your living trust up to date. Now let's talk about an example scenario. So consider a couple of clients I had, we'll just call them John and Jane. And John opted for a will that left everything to Jane, his wife, and their children after his death. And after John passed away, Jane had to go through the probate process, and that took several months, and it incurred some legal fees. So Jane thought to herself, gosh, I'd really like to make things easier for our kids, Sally and Susie, when I die. So she decided to set up a living trust for her estate. And then when she passed away, her assets were distributed out directly to Sally and Susie. We didn't have to wait. We didn't have the costs of probate. Furthermore, if Jane became incapacitated, luckily she didn't, but if she had, her successor trustee, her daughter Sally, would be able to step in immediately and take over, ensuring her financial affairs are managed without needing to go through any kind of court intervention. So in summary, both wills and living trusts have their benefits and drawbacks. A will is obviously simpler, less expensive to create, but it does require probate after you've passed away, and that can be costly and time-consuming. A living trust, on the other hand, avoids probate and provides more control and privacy, but it's more complex and costly to set up. So understanding these differences now can help you make the best choice for your estate planning needs. For more estate planning tips and strategies, check out our next video, and don't forget to subscribe and hit the notification bell so you never miss an update.